Hello and welcome to another webinar in Fieldfisher's Get Data Protection Fit series. My name's Kirsten Whitfield and I'm a Director in Fieldfisher's Privacy, Security and Information Law team. And I'm joined by Charley Guile, who's a trainee solicitor in our team. So this is a segment in our Get Data Protection Fit series. We're now on to segment 5, what needs to go into a privacy notice. Parts 1 to 4 of this module 1 are available on our YouTube channel and details of this will be provided at the end.
So, what are today's learning outcomes? In part 2 of this module, our colleagues spoke about one of the key GDPR principles, transparency. This means being clear, open and honest about how and why you are using the personal data of individuals. And in the previous part of this module, part 4, one of the data subject rights mentioned was the right to be informed about data processing. So in this part 5 of module 1, we're going to try and bring this all together to talk about how you comply with these requirements. And in practice, how you do this is to provide a privacy notice to those individuals, which sounds very easy, but in practice, this can be quite hard to get the balance right between providing all the information you have to give and at the same time making sure your notices are concise, clear and easy to read, which are also GDPR obligations. The list of what you need to tell people is set out in the GDPR itself, and the list is much longer than it was pre-GDPR. In today's session, we will cover drafting a privacy notice and what to include, the timing for delivering the privacy notices, the different formats that privacy notices could take, and identifying the exemptions to the obligation to provide a privacy notice. Like the previous part of this module, part 4, this part 5 is aimed at controllers. This is because it is the controller's responsibility to provide a privacy notice and not a processor responsibility. So, the right to be informed. When do you need to inform individuals about the information you collect about them? Articles 13 and 14 of the GDPR deal with this. Essentially, when you process any personal data about an individual as a controller, you will need to provide a privacy notice to the individual unless one of the few exemptions applies. As outlined in part 1, personal data is information relating to an identified or identifiable person. This means information about a person which allows you to directly identify the individual, or if you can identify the individual by putting 2 and 2 together, to come up with 4. And the GDPR applies to any processing of personal data. As outlined in part 1, processing is a very broad concept and essentially can cover just about any action you can think of involving personal data, whether that's collecting personal data, holding the personal data, even if that's just for archive, updating the personal data, and the list goes on. The right to be informed can be split into 2 categories of collection. First of all, you have direct collection. This involves collecting the information directly from the individual that the information relates to. For example, where the individual fills in a contact form on your website, if the individual submits a CV through a recruitment portal, or they might send you an email about your products or services. Here you are collecting the information directly from the individual about that individual. And the second is indirect collection. This involves the collection of information about an individual from a source other than the individual themselves. For example, if you obtain a reference about the person from a former employer, or if you purchase a marketing list from a third party, or you might track the individual's browsing habits on your website. This distinction between these two is very important, as this can impact the content and the timing of the privacy notice. So, as I said, the timing for providing privacy notice will depend on whether the information is collected directly or indirectly from an individual. Where you're collecting the information directly from that individual, you should be providing the information at the time you obtain the data or the information is collected. Alternatively, if you are collecting the information indirectly, it's unlikely that this is even achievable. So the information should generally be provided within a reasonable period of time, and at any rate, no later than 1 month after the information was collected. If you are using the information to communicate with individuals, i.e. if you've collected an email address, That information should be provided to the individual at the latest at the point of that first communication with the individual. And if you envisage that you will disclose the personal data to a third party, then the notice should be given to the individual at the latest point when the information is disclosed to that third party.
And now we're going to have a look at some of the exceptions. So there are a few exceptions to this obligation to give individuals a privacy notice. One of the exceptions is that the person already has the information, and that one applies whether you've collected the information directly or whether you're collecting it indirectly. And there's a few more exceptions that apply only to indirectly collected information. If it would be impossible or involve disproportionate effort to give a privacy notice, then you don't need to give the privacy notice. Now, different data protection regulators may take different views on what they consider disproportionate effort, and there has actually been a case on this in Poland, which demonstrated that the regulator there, at least, would actually expect pretty considerable effort and expense on the controller's part to deliver that privacy notice. Now, the least risky course of action would then be to provide a privacy notice rather than risk not seeing eye to eye with the privacy regulator. It's also the case that if actually it would make the processing purpose impossible or seriously impair it, you don't need to give a privacy notice. Now, to give you an example here, let's say you're investigating some illegal activity and giving the privacy notice would tip off the individual and give them the opportunity to cover their tracks. Now, in that situation, you wouldn't need to give that privacy notice and tip off the individual. If there's a legal obligation to collect or disclose personal information, then again, you don't need to give a privacy notice. And also, if you've got a duty of professional secrecy, you don't need to give a privacy notice. So, for example, that would apply to lawyers. So now we're going to take a look at what actually needs to go into your privacy notice. And as mentioned previously, it's actually a considerably longer list now under the GDPR than it was pre-GDPR. So first off, you need to give the name and contact details of the controller of the information so that people know who they can contact and who you are. If you appointed a data protection officer, then you should also be giving the name and contact details of your data protection officer, bearing in mind that actually the data protection officer's role is to be a point of contact for regulators and for data subjects. You need to explain to people what the lawful basis of processing personal data is. Now, the lawful basis of processing was covered in Part 3 of Module 1. For example, your lawful basis could be consent. It could be to perform a contract with the individual, or it could be for your legitimate interest, and so on. If you are relying on legitimate interest as your lawful basis for processing information, then you also need to tell people what your legitimate interest is. Now, taking a recruitment example, individuals may be sending their CVs to you, and you may be giving them a recruitment privacy notice. And your legitimate interest there would be to find a suitable candidate to fill a vacancy. You also need to explain to people what their data subject rights are under the GDPR. Those rights were covered in Part 4 of this Module 1 in our series. If you're going to be carrying out any automated decision making, you need to tell people about that. So automated decision making is when a decision's made but without any human intervention. So taking the recruitment example again, if you've, say, got a very large number of candidates for a job and you want to test them using some online testing tool to down select people for the job, that would be done automatically. That's an automated decision. So if you're making automated decisions, then you also need to tell people that they have a right not to be subject to an automated decision if it will have a legal or other significant effect on the individual. So in a recruitment example, because people could be down selected and removed from the recruitment process, that actually could be quite a significant effect on them. So this would apply. You also need to tell people about the logic involved in the decision and also the significance and the envisaged consequences of this automated decision making for the individual. And the European Data Protection Board have issued some handy guidance on this, which explains in more detail the sorts of things that you might want to be telling people. You also need to tell people in your privacy notice how long you're going to keep their information for. Now, regulators would like, in theory, to see a lot of detail here, but in practice, actually, this can be quite difficult to give all of the retention periods for all of the personal data that might be collected. So in practice, what tends to happen is that a fairly high-level statement is made in a privacy notice, but then an organisation may well then hold a retention policy and hold the information in accordance with their retention policy. And the retention policy would be an internal document. Although you do need to comply with that retention policy, and there has actually been a case in Europe already of an organisation that had a retention policy but didn't stick to it.
And I'm afraid that list isn't over there. There are further things you need to include in your privacy notice. So first of all, for the purposes of your processing. So for the different types of personal data being collected, you must explain the reason that it's being collected. If there could be additional reasons later on for you having that information, that also needs to be communicated to the data subject. You also need to give details of any recipients of the personal data. If you envisage that the information will be or could be shared with third parties, you need to explain who those third parties are, or give categories of those third parties. Depending on the context, it will dictate which option you choose. If, for example, there are only a few processes that could see the data, then it might be more appropriate and easier enough just to list them out. However, if you have a lot of processes and they might change frequently, it'd be better to simply flag that your third-party providers may receive personal data and try and categorize those. The transfers to third countries, what this actually means is listing out any transfers outside of the European Union, as well as explaining what countries outside of the EU the data may be sent to. The privacy notice should also explain some sort of safeguards that are in place. International data transfers will be discussed in further detail in our next module, but privacy notice should explain whether there are any adequacy decisions in place for the country to which the data will be transferred, or what other GDPR safeguards for transferring data are in place, i.e. do you have Privacy Shield in place for transfers to organizations in the US? Are there standard contractual clauses in place, which are contracts approved by the European Commission for the transfer of data outside of Europe? Or are there any binding corporate rules in place, which is a set of terms agreed by a group of organisations for the transfers of personal data, and which are reviewed and approved by relevant data protection regulators? Specifically, if the information is collected directly from the individual, you also need to let the individual know whether they are legally or contractually required to provide that information to you. And the last two relate solely to where you are collecting the information from a third party and not directly from the individual. So you need to disclose the categories of personal data obtained, and the source of data should also be disclosed. For example, if you're obtaining contact details from a third party marketing list broker. So you now know what information you need to provide and why you need to provide it, but how? And does the GDPR dictate how you should do this? So under Article 12 of the GDPR, the controller must provide information referred to under Article 13 and 14, which we've just discussed in the table, in a concise, transparent and intelligible manner, and in an easily accessible form using concise, clear and plain language. And it must be provided free of charge, although this is not usually a problem. What can often be more difficult is crafting a privacy notice that includes all the information that you need to give, but is also conveyed in a concise and easy to understand way, bearing in mind that you should also be taking into account your audience. People could have varying degrees of tech savvy, they could be of different ages, So, for example, if your website is aimed at sort of a teenage audience, you need to make sure those teenagers are able to understand your privacy notice and what you'll be doing with their data. Moving on to some top tips, I think Kirsten is going to give us some top tips on privacy notices.
I will indeed. Thank you, Charlie. So, in terms of top tips, just-in-time notices are a good idea so that you are delivering information to people just at the time that it's going to be most relevant and useful to them. So to give you an example, and I'm going back to recruitment again, you may already have given a recruitment privacy notice to someone when they submitted their CV, and then later on you might be getting them to do an online test. And at that point, it might make sense to deliver to them the information that you need to give around automated decision making, because at that point it's most helpful for them and acts as a reminder. You might also want to use dashboards so people can then navigate around different aspects of the privacy notice using the dashboard. And also bear in mind that your cookies notice and your list of your cookies and what they are and what they do, that could actually on a website be part of your dashboard. It's a layer of your privacy notice. And talking of layers, layers are useful because not everybody wants to delve into the full detail of a privacy notice. I confess that sometimes I don't want to. And so it's nice to have a very brief, succinct layer, for example, as the top layer. And then if you really want to read the detail, then you can drill down into the detail and read it. You could also have layers where you have lists. For example, if you don't want to list all of the third parties you're sharing information with within your privacy notice, you could have a link. And behind that link, you could then list the third parties. And what's also useful there is that you can then change those lists as and when your third parties change. You can also use tools like videos and voice recordings within your privacy notice, because actually privacy notices don't have to be given in writing. They could be verbally as well. And finally, it's also a good idea to look at examples of what others are doing. So you might even want to look at privacy regulator websites for examples of good website privacy notices. And take a look, for example, at the Information Commissioner's Office, their own website, and how they've done it there.
So as we draw to the end of the session, you should now be more equipped than you were at the beginning anyway to draft a privacy notice, understand what you should be including in it, understanding the timing for when you should deliver a privacy notice to individuals, whether you're collecting the information from them or from a third party, and understand the formats providing privacy notices to individuals, and also to be able to identify any exemptions that you may have to providing a privacy notice.
So that brings us to the end of segment 5 of module 1, so what needs to go into a privacy notice. And there remains one more segment which will be following on, and that is international transfers of personal data.
Hi, thank you for taking the time to listen to our webinar today, the 5th in module 1 of our Get Data Protection Fit series. Our contact details are on the slide in case you do have any questions. And there is also a link to our YouTube channel where you can find the other modules on there, and you should subscribe to receive updates of when our next modules will be released. You can also find a link to a useful information on the ICO website if you have any further questions around this topic or any other data protection topic, and also our Fieldfisher blog. Please feel free to sign up to that. There's lots of useful articles that are produced on there. Thank you.
Thank you, everyone.